Your kids can have family 5 minutes away and still end up in temporary protective custody of Child Protective Services. Not because grandma doesn't love them enough, but because in Colorado, love is not the same thing as legal authority. And there's the gap that the parents don't see coming. In the space between a crisis and a judge's order, and that space your child can be waiting. Here's what I want you to learn today. I want you to understand why guardianship isn't automatic in Colorado and in most other states. I want you to see the difference between a plan that only protects your kids after death and the one that protects them while you're still alive. And I also want you to leave with calm, practical next steps that you can take today to make sure that your kids never have to be in this situation. The story I'm about to share is fictional, basically a fictional client story, but I've actually seen it happen in real life. Let's talk about Emily and Ryan. They're just a normal family. They have 2 kids, 3 and 5, and everything is fine. And they actually named a guardian in a will, saying that if they both pass away, their kids will go to their grandparent. But one weekend, they drive home and they get into a car accident where both Emily and Ryan are temporarily incapacitated, unconscious, and they have to be taken to the hospital. What happens in that scenario? Grandma and grandpa do not have legal authority to even be notified that something happens. Here's the thing, first responders do not want to take on the liability of trying to find next of kin. If you don't have any legal paperwork, then they won't go through the bother of trying to locate. They will just call CPS. Here's the sad truth number 2 is that even if grandma and grandpa show up at the hospital, they don't have any legal authority to take your kids. They can't do anything, and it becomes very, very stressful for the kids. When guardianship isn't documented, families face 3 kinds of fallout: emotional, practical, and financial. Emotional risk comes first. Children in crisis don't need a process. They need a person. They need a familiar voice. They need a familiar home. Every night with a stranger can be potentially traumatic for their whole entire lifetime. Practical risk is next. Without legal authorities, loved ones cannot make their decisions. Immediate expenses still exist. They still have to make decisions about what kind of treatment to give you, who can talk to the hospitals. Agencies can't just accept, well, I'm the grandma or I'm the grandpa. It simply does not work that way. And the financial risk also shows up quickly. While you're incapacitated at the hospital, who's there to provide for your minor kids? They can't go to work and pay the bills or pay the mortgage. And would you expect the grandparents to pitch in? Will they be able to go in and pay your own health insurance premium? Will they be able to take care of the finances as you're temporarily incapacitated? The answer is that without plain legal authority, they simply cannot. Because even if the family agrees, the agreement is not an order. It's basically just a verbal agreement and that does not have any legal authority. So here's the part that surprises a lot of parents. They just assume that because you have family in the state, they will have default guardianship. But guardianship is not automatic. A lot of people ask, well, why isn't it? And the truth is that it is about protection. And the Colorado courts are required to have the child's best interest at heart. And they don't know your family dynamic. They don't know who's the safe choice. They don't know if grandma has an addiction problem. They don't know if grandpa has a history of abuse. That's why they have to go through procedure to determine who is actually fit to become your kid's legal guardian. And procedure, unfortunately, takes time and money. Calendars fill, filings take time, hearings require notices, public publications in local newspapers. A lot of the people just don't realize that this will take a lot of time and money. A naming guardian in the will is simply not automatic. Even if you have a guardian named in the will like Emily and Ryan did, first of all, it doesn't work in an incapacity situation. But second of all, even if they pass away and grandma and grandpa try to become guardians, they still have to go through probate with the will. And the court will still try to evaluate if they're a good fit. So what does an actual proactive plan in Colorado look like? You don't just need to name guardians in a will. You need to have a few pieces to this puzzle. And you actually have to document it, share it with your named guardians, and carry it on you at all times. We call it an emergency ID card. So other than naming guardians as to what happens if you pass away, you also can name emergency guardians, and they don't have to be the same people as the long-term guardians. A lot of our clients have family that are out of state. But what if something happens to you and you need somebody to come get your kid right away? Your emergency guardian does not have to be the same person as the permanent guardian. It just has to be somebody that you trust, that knows that they're named, has a copy of the guardianship, and can show up to the scene of the accident or to the hospital with legal proof that they have authority to take your kids. And then you get a little emergency ID card that you carry in your wallet at all times that will actually let the first responders know who to call in case of emergency and who has the legal authority to take your kids. If you want a calm place to start with some practical considerations, here's the 5 steps that I'm going to share with you. First, you have to name short-term guardians. Then you have to nominate permanent guardians. And again, they don't have to be the same people. A third piece is that you also have to determine who's going to have medical decision-making over your kids in case both parents are incapacitated, and the kids may also need need medical care. So that's a medical power of attorney over the kids. And then you also have to share all of this, write down any specific instructions that you may want the guardians to have. And then finally, you have to communicate your plan. Not only your plan and just sharing the guardianship forms, you also need to make sure that your guardians know the major no-nos or the major things that you would never be okay with. And because I never want this to be too stressful on a parent, we will actually handle all of this for you if you just come to the firm for a free consultation and tell us about your concerns and whether you have people named or if you're just looking to get that done. When planning is done well, it doesn't just protect your children. It gives you the peace of mind that you are a good parent for taking care of this. And it protects your family relationships too, because nobody will end up in court fighting over who has the legal authority to take your kids. So if this gave you one new thing to think about in 2026, I would encourage you to come to the firm and actually sit down with me and talk through all of these issues and make sure that you have properly designated legal authority for all of your kids and also for the people that you would trust the most. This is what we do here at Legacy Law Group. It's not just about the paperwork. It's about educating you on all of the practical implications and all of the what ifs and covering all of them for you. So I hope you like this video. Please follow us to not miss any of our new content, and I look forward to meeting with some of you in 2026.